Hello everyone, I am Kanchan and welcome to Apti Plus Academy for Civil Services, our premier institution for preparing for civil services in India. Today, I am here for a daily news and editorial analysis for 2nd of March and 4th of March 2024, and this editorial analysis is going to be important for all three stages of UPSC, which are UPSC prelims, mains and interview process. And apart from UPSC exams, this editorial analysis is going to be important for all the government exams in India. So without further delay, let us begin the analysis. Recently, the Law Ministry of India proposed to establish regional benches for the Supreme Court of India, and in this context, this news becomes important for UPSC prelims perspective and also for the GS2 of UPSC mains. And under GS2, the topic that this news caters to is Indian judiciary and Indian constitution. The point of discussion of this topic is going to be the regional benches of Supreme Court. We'll understand what are the regional benches of Supreme Court. Then we'll discuss the need for the regional benches of Supreme Court in India. Then we'll discuss the argument against the regional benches of Supreme Court of India. And lastly, we'll discuss the PYQ that has been asked from the similar topic. So let us begin the analysis. The proposal to establish the regional benches for the Supreme Court of India is not new in India, and previously as well the Parliamentary Standing Committee on Personal, Public Grievances, Law and Justice had proposed regional benches for the Supreme Court of India nationwide. And on this direction, recently the Law Ministry also proposed to establish the regional benches for the Supreme Court of India. So what are the regional benches of Supreme Court? The regional benches of Supreme Court are proposed benches of the apex court established in various parts of country to decentralize the judicial authority and increase the accessibility of justice. So to ensure the decentralization of judicial authority and to increase the accessibility of justice, the regional benches are proposed for India. So far as the need for regional benches of Supreme Court of India is concerned, the first and foremost reason for establishing the regional benches of Supreme Court of India is that there is a significant backlog of cases in Supreme Court of India, and as per the figures, more than 80,000 cases in Supreme Court of India are waiting for the resolution, and this backlog in judicial system is causing a strain on the existing judicial infrastructure, and this is also causing the inefficiency in judiciary system in India. So to reduce the burden of huge amount of cases pending before the Supreme Court of India, regional benches of Supreme Court in India is needed. The workload that is currently concentrated in the Supreme Court of India will be distributed across the regional benches, and thus the workload in the Supreme Court of India will be reduced. The third important reason for establishing the regional benches of Supreme Court of India is to ensure the accessibility of justice. Because currently the people from different parts of India have to travel to Delhi for different cases or to file the cases in Supreme Court of India. So establishing the regional benches of Supreme Court of India would reduce the need for traveling to Delhi for resolution of different cases. And also the establishment of regional benches of Supreme Court of India would lead to reduction in the travel expenses for the litigants and the legal professionals, and this would further ensure the access to justice by the people of India. The establishment of regional benches of Supreme Court of India would ensure that the Supreme Court of India focuses solely on the constitutional issues and the issues which are of grave importance for the national interest. So the establishment of regional benches of Supreme Court of India would lead to specialization of Supreme Court of India in case of constitutional matters only. So this would ensure that the Supreme Court of India in Delhi would focus on the constitutional matters only, and the regional benches focuses on the other matters. So these are the important reasons for establishing the regional benches of Supreme Court of India. Now let us discuss the arguments against the establishment of regional benches of Supreme Court of India. So far as the arguments against the regional benches of Supreme Court of India is concerned, the first argument against this is that the regional benches could lead to disintegration of the institution of Supreme Court of India. The second argument against the regional benches of Supreme Court of India is that the regional benches might lead to regional biases or the political influence to impact the judicial decision at regional benches. So the political influence might affect the institution of judiciary, and also the regional biases might be there in the regional benches of Supreme Court of India. The third argument against the regional benches of Supreme Court of India is that the establishment of regional benches would require significant financial resources and also the investment in infrastructure. So the establishment of regional benches would require the huge amount of capital and the manpower for the Supreme Court of India. And the last important argument against the regional benches of Supreme Court of India is that the regional benches may overshadow or weaken the central authority of Supreme Court of India. So the authority of Supreme Court of India would be reduced, As I just discussed that the Supreme Court of India is the highest court of authority in India, so the regional benches might overshadow or weaken the central authority of the Supreme Court of India. So these are the important arguments against the regional benches of Supreme Court of India. Now let us discuss the viewpoints of the legal experts on the regional benches of Supreme Court of India. The Article 130 of the Constitution of India says that the Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of the President, appoint from time to time. So, as per the Article 130 of the Constitution of India, the seat of the Supreme Court shall be in Delhi or any other places. But the Chief Justice of India, while establishing the regional benches of Supreme Court of India, should have the prior approval of the President of India. So, basically the Chief Justice of India can establish the regional benches of Supreme Court of India with the prior approval of the President of India. So, this provision of Article 130 provides for the regional benches of Supreme Court of India. And so far as the Law Commission of India is concerned, the 229th Law Commission report of 2009 also recommended for the establishment of 4 regional benches of Supreme Court in Delhi, Chennai, Hyderabad, Kolkata and Mumbai. So, the 229th Law Commission report also recommended for the establishment of regional benches of Supreme Court of India, and the Bar Council of India in 2021 also recommended for the regional benches of Supreme Court of India. And in this recommendation, the Bar Council of India specially recommended for establishing the regional bench in South India. However, historically, no Chief Justice of India has so far supported the establishment of regional benches of Supreme Court of India, because the Chief Justice of India believes that the establishment of regional benches of Supreme Court could potentially lead to reduction in the authority of the Supreme Court of India and the prestige of Supreme Court of India. So these were the viewpoints of the legal experts and the provisions contained in the Article 130 of the Constitution of India. Now let us look at the PYQ that has been asked from the similar topic. UPSC in 2021 asked this question related to the Supreme Court of India and the judges of Supreme Court of India, and the question was, with reference to Indian judiciary, consider the following statements. Statement 1 is, any retired judge of Supreme Court of India can be called back to sit and act as the Supreme Court judge by the Chief Justice of India with the prior permission of the President of India. Statement 2 is, a High Court in India has the power to review its own judgments as the Supreme Court does. Which of the statements given above are correct? So, 2 statements related to Supreme Court of India and its judgments has been given. So, this question basically talks about the acting judge of the Supreme Court of India and the power of review of the High Court of India. So, this is a very simple question. Comment the answer of this question in the comment section. Now, let us move into another topic of discussion for today. Before I move into another topic of discussion for today, I have an important announcement for you. Those who are appearing for UPSC CAC Prelims 2024, 𝐁𝐤 All India Test Series program is must attempt for all, because this test series contains 4900 high quality questions curated by the experts from Apti Plus Academy for Civil Officers, and the recorded discussion classes on these questions are also available. And the most important feature of this 𝐁𝐤 All India Test Series program is that the money will be refunded to the students if the students finds this test to be unsatisfactory. So this is the golden opportunity for you all, and you should not miss this opportunity. So now let us move into another topic of discussion for today.
महाराष्ट्र में अब मराठाओं को 10% आरक्षण मिलेगा। महाराष्ट्र की एकनाथ शिंदे सरकार ने 10% मराठा आरक्षण को मंजूरी दे दी है। मंगलवार को महाराष्ट्र विधानसभा के स्पेशल सेशन में एकनाथ शिंदे कैबिनेट से इस प्रस्ताव को मंजूरी मिल गई है। वहीं अब बताया जा रहा है कि इसके तहत राज्य में मौजूद 28% मराठा समुदाय के लोगों को 10% आरक्षण सरकारी नौकरियों में दिया जाएगा। इसके अलावा इतना ही हायर स्टडीज इंस्टीट्यूशंस में भी रिजर्वेशन देने का प्रस्ताव है। बीते एक दशक में यह तीसरा मौका है जब महाराष्ट्र में इस तरह का बिल मराठा समुदाय के लिए मंजूर किया गया है।
Maratha Assembly recently passed the Maharashtra State Reservation for the Socially and Educationally Backward Classes Bill 2024, and this bill provides for the 10% reservation for the Maratha community in jobs and education under the socially and educationally backward categories. So the 10% reservation would be provided for the Maratha community. And so far as the provisions of the bill is concerned, the bill specifies the Maratha community as the socially and educationally backward class under Article 342A subclause 3 of the Indian Constitution, and it also provides for the reservation for the Maratha community under the Article 15 subclause 4 of the Constitution of India, Article 14 subclause 5 and the Article 16 subclause 4 of the Constitution of India. And the bill ensures that the principle of the creamy layer is applicable to the Maratha community. That means the reservation would be restricted to the Maratha community who are socially and educationally backwards only. So the Marathas who are not in the creamy layer category would not be able to enjoy the benefits of this bill. And the most interesting part of this bill is that the 10% reservation that is provided to the Maratha community exceeds the 50% reservation criteria which was provided by Supreme Court of India in the 𝐸𝐸𝐻𝐈 judgment of 1992. So in 𝐸𝐸𝐻𝐈 judgment of Supreme Court of India in 1992, the ceiling for reservation was provided as 50%, but this bill exceeds the ceiling of 50% criteria provided by this 𝐸𝐸𝐻𝐈 judgment. And this 10% reservation for Marathas in Maharashtra will now take the total reservation in Maharashtra to 62%. So these are the important provisions of the bill. Now let us look at the provisions of Article 342, Article 15 and the Article 16 of the Constitution of India for prelims perspective. Article 342A subclause 3, Article 15.4 subclause 4, Article 15.5 subclause 5 and the Article 16 subclause 4 are very important for UPSC prelims perspective, because Article 342A subclause 3 provides for the list of socially and educationally backward classes in the states. So that means every state or the union territory can prepare or maintain a list of socially or educationally backward classes, and this list would be different from the socially and educationally backward classes list of the central government. So this article is basically used by the state government to provide the reservation for the backward classes in states. And so far as the Article 15 subclause 4 of the Constitution of India is concerned, this article empowers the state to make these special provisions for the advancement of any socially or educationally backward classes of citizens or the scheduled caste and the scheduled tribes. So basically this article empowers the state government to make special provisions for any socially or educationally backward classes of citizens, which includes scheduled castes and scheduled tribes. And so far as Article 15.5 of the Constitution of India is concerned, this article provides for the provision for the reservation of seats for admission to educational institutions for the backward classes. And the Article 15 subclause 5 of the Constitution of India relates to the provision for the reservation of the seats for the socially and educationally backward classes of citizens, including the scheduled caste and scheduled tribes in educational institutions. So the reservation for the socially and educational backward classes and also for the STs and SCs are provided under the Article 15 subclause 5 of the Constitution of India. The exception of Article 15 subclause 5 of the Constitution of India is that this reservation in the educational institutions shall not be applicable in the minority educational institutions. So you have to remember the difference between Article 15.4 and the Article 15.5 of the Constitution of India. So Article 15.4 makes the special provisions for the SCBCs, and the Article 15 subclause 5 provides for the reservation in the educational institutions. And so far as the Article 16 subclause 4 of the Constitution of India is concerned, this article authorizes the state to make the special provision for the reservation for the appointment or the post in favor of any backward classes of citizens. So the provision for reservation for any backward classes of citizens in India is provided under Article 16 subclause 4 of the Constitution of India. So remember this difference, that Article 15.4 relates to the special provision for SCBCs, Article 15.5 relates to the reservation for the socially and educationally backward classes of citizens in educational institutions, and the Article 16 subclause 4 provides for the reservation in government jobs. So these are the important articles of the Constitution of India that you should know about the reservation in India. Now let us move into another topic of discussion for today. Recently, the 1300-year-old inscription and the temples related to the Chalukyan period was discovered in South India, and in this context, this news becomes important for UPSC prelims perspective and also for the GS2 of UPSC mains. And under GS2, this topic falls under the syllabus effect of policies and politics of countries on the India's interest. And in this topic, we are going to discuss about the Badami Chalukya temples. We'll understand about the Chalukya temples and its architecture. So let us begin the analysis. So, as we just discussed, the context of the news is that the recently 2 Badami Chalukya temples estimated to be around 1300 to 15 years old, along with the 1200-year-old level inscriptions were recently discovered from the Mudimanyakam village on the banks of river Krishna. So, 2 temples and the inscription has been discovered, and this is very important for UPSC prelims perspective. So, talking about the Chalukyas of Badami, this kingdom was established by Pulakesi I in 550 AD, and the Chalukyas of Badami ruled from the Badami, which is also called Vatapi in Karnataka, and they were particularly known for the unique Vesra style of temple architecture. So, the Vesra style of temple architecture was basically started by the Chalukyas of Badami, and this architecture is the blend of the South Indian and the North Indian style of temple architecture. So, in the Vesra style of temple architecture, you would find the features of both the Dravidian style and the Nagara style of temple architecture. So, these were the important facts about the Chalukyan temples. Now, talking about the Chalukyan architecture do not have the covered circumambulatory path. So, the circumambulatory paths are basically the paths and around which the devotees walk, and in Chalukya style of temple architecture, the circumambulatory path, which is also called the Padakshina Patha, is not covered. And if you see in North Indian style of temple architecture, the Padakshina path is covered by some wall. And the most important temples which were built during the Badamis of Chalukyas were the Virupaksa temple, which is also called the Patadagal temple, and the Rameswaram temple, which was built at Ellora in 7th century, and Latkhan temple and the Durga temple located in Aihole in Karnataka. So, these are the important temples which were built during the Chalukyan period. So, you need to remember about these examples, because in UPSC prelims and in other exams you might be asked that the Virupaksa temple and the Durga temple built during the Chalukyan period is the type of which type of temple. So, you need to remember names of these examples of temples. So, these were the important facts about the Badamis of Chalukyas and the Chalukyan architecture. Now, let us move into another topic of discussion for today. Recently, the Indian gharials were sighted in the greater Kaziranga landscape, and in this context, this news becomes important for UPSC prelims perspective and also for the GS3 of UPSC mains. And under GS3, this topic caters to the syllabus, the conservation efforts. And in this topic, we are going to discuss about the gharials and its conservation efforts. Then we will discuss about the types of crocodiles in India, and lastly, we will discuss about the conservation status of these crocodiles in India. So, let us begin the analysis. This news is very important because the critically endangered crocodile, which is the gharials, have been spotted in the Kaziranga landscape for the 3rd consecutive year. And the presence of gharials in the Kaziranga landscape signifies the abundance of freshwater fish species in the Kaziranga. So, for this reason, this topic is important. So, talking about the gharials are also called gavials. It is a type of Asian crocodile, and it is distinguished by long, thin snouts. So, they have very long and thin snouts, and the population of gharials is a good indicator of clean water. So, the gharials are mostly present in the clean water, and it is known to be relatively harmless and fish eating species. So, gharials basically eat the freshwater fishes, and so far as the habitats of gharials are concerned, they are mostly found in the fresh waters in the Himalayan rivers, and the primary habitat of the gharials are Chambal river, and the secondary habitats are Ghagra river, Gandak river, Girwa river, Ramganga river, Son river, etc. So, these are the secondary habitats, and the primary habitat is the Chambal river. And so far as the conservation status of gharials are concerned, they are listed as critically endangered in the IUCN list of threatened species category, and they are listed in Appendix 1 of the CITES, and also they are protected under the Schedule 1 of the Wildlife Protection Act of 1972. So, these are the conservation status of the gharials. And apart from gharials, there are other 2 types of crocodiles which are found in India, because basically there are 3 types of crocodiles found in India. Now, let us discuss about the other 2 types of gharials which are found in India. The second type of crocodiles which are found in India are the mugger crocodiles, and also called the marsh crocodiles, and habitat of this crocodile is restricted to the freshwater habitats and also in the coastal seawater lagoons and estuaries. So, they are basically found in the freshwater and the lagoons and estuaries, and it is already extinct in Myanmar and Bhutan. So, this species is extinct in Myanmar and Bhutan, and so far as the conservation status of the marsh crocodiles are concerned, they are listed as the vulnerable under the IUCN list of threatened species category, and they are listed in Appendix 1 of CITES and also in the Schedule 1 of the Wildlife Conservation Act of 1972. So, these are the conservation status of the marsh crocodile or the mugger crocodile in India. The third type of crocodile which is found in India are the estuarine or the saltwater crocodile, and they are also known as the man eater because they can eat the man alive. And so far as the habitat of saltwater crocodile in India is concerned, they are mostly found in Bhitarkanika National Park in Odisha and in Sundarban region of West Bengal, and also in the Andaman and Nicobar Islands in India. And talking about the conservation status of the saltwater crocodile in India, they are listed as the least concern in the IUCN list of threatened species categories, and in CITES they are listed in Appendix 1 except for the population of Australia, Indonesia, Papua New Guinea, which are included in Appendix 2. So, in CITES they are included in Appendix 1 and Appendix 2, but in Appendix 2 only the populations from Australia, Indonesia and Papua New Guinea is included, and they are also protected under the Schedule 1 of the Wildlife Protection Act of 1972. So, these are the conservation status of the saltwater crocodile and the marsh crocodiles. So, we talked about three types of crocodile. Now, let us see the pictures of these type of crocodiles which are found in India. So, these are the three types of crocodile species which are found in India. The first one is the gharials, and you can identify this type of crocodile by looking at the long snout, and this is the mugger crocodile which are found in India, and this is the saltwater crocodile which is the largest species of the crocodile which are found worldwide. And you can see in the picture this type of crocodile is very large, and this type of crocodile can also eat the man alive. So, these were the important facts about the crocodiles which are found in India, and this was also the last topic of discussion for today's daily news and editorial analysis. And today as well I have come up with an important quote of the day for you. Now, let us look at the quote that I have got for you. Today's quote of the day is very important for our everyday life, and this quote was given by Mahatma Gandhi, and this quote has been asked in UPSC essay paper and the ethics paper in multiple occasions, and for this reason this quote is very important, and the quote is quote unquote, "Be the change that you wish to see in the world." And this is a very important quote, and you must inculcate this quote in your everyday life. So, with that quote I am concluding today's session. We will meet again in the next video. Till then, take care.